Hi there, my name is Eleissa Lavelle. I have been a lawyer in Nevada for more than 35 years. The focus of my practice now is alternative dispute resolution, arbitration, and mediation. And I work with JAMS, which is a dispute resolution provider in Nevada and throughout the country and the world. I'm going to talk to you a little bit today about alternative dispute resolution. It's a buzzword. Many of you have had classes at law school about these subjects. But the nitty-gritty of it has some real value for you, and I want to talk in some detail about both mediation and arbitration so that you understand what these processes are, how you can benefit from them, and how you can offer them to your clients so that they can achieve great benefit. The first thing I'm going to talk about is mediation. Now, you all learned how to negotiate. Many of you have negotiated since the time you were little kids. But sometimes, as you know, mediation can help you because negotiations can break down. You reach an impasse. People get angry. People get emotional. Your clients may not want to hear what you have to say, or you may be uncomfortable telling them what the bad news is going to be. So in these kinds of situations, mediation can be very helpful by having a third party in the room who is a neutral, who is respected, who is an expert in the process of mediation, and may have an expertise in the subject matter of your dispute. The purpose of having that person there is to help you help your client evaluate the case, evaluate their options, create options, and hopefully reach a resolution of the disputes. Now, mediation is a forward-thinking activity, whereas litigation looks backwards. Litigation's purpose is to find out who's at fault, discover the truth, whatever that means, determine guilt or innocence, and allocate damages accordingly. The purpose of mediation and the real benefit and promise of it is that it helps the parties to look forward, to put the dispute behind them, to solve the problem, and maybe even expand their solutions and offer some creative possibilities for them. As an example, I did a mediation recently where parties were fighting over tenant improvements on a warehouse lease. They were trying to figure out who was right, who was wrong, and how much money each party was going to spend on the resolution. What happened through the mediation process was not only did they settle that dispute, but they resolved future problems that they knew that they were going to handle. They worked out their own relationship issues. They ended up rewriting the lease, extending the term, and moving well beyond what litigation could have achieved for them, well beyond just who was right and who was wrong and how much the damages were going to be. So this is the real possibility of mediation. But it's a process that each of you, when you undertake it, still requires work, still requires expertise. So let me tell you a little bit about what the advantages are and why you might consider it and when you might consider it. You're going to consider it, for example, if your client is really emotional and needs to tell a story to somebody and you have a difficult time getting them off the ceiling or out of the tree to talk about finally getting this thing behind them. So you bring in a neutral to give these clients an opportunity to vent, to handle their emotions, to speak candidly, to tell their story to somebody who understands what they're talking about and is trained to help them get through it. Not a psychotherapist, obviously, but in a legal context so that they can see what went on, what could their possibilities be in getting the case resolved. There are benefits, for example, in having the case be confidential. Everything that you tell a mediator, if you tell the mediator that it's confidential, is going to stay confidential. So things like trade secrets, things that you may not want the other side to learn in discovery, issues that are private and that your client may not want disclosed can very well be handled through a mediation process, whereas if it were to be litigated, all the dirty laundry comes out and problems can ensue from that. Clients are encouraged to speak in mediation. They're encouraged to be candid. Lawyers are encouraged to be candid. It's through that very candor that the people involved are able to reach a resolution, that possibilities emerge, that their interests are discussed, and that they can move on from where they were to where they need to be. And most of all, mediation, as all alternative dispute resolution processes, is consensual. You and your clients are in control of the situation. If the clients don't want to go forward, they don't have to. Nobody's forcing them. They are there to make a deal if they can, with the assistance of a mediator who can help them through the process. So what's the role of the mediator? The role of the mediator is not just a water carrier. It's not just to pass offers back and forth. It's to be part of the process, manage the process so that everybody can get more out of it than simply somebody running numbers back and forth. The mediator's role is to focus the clients and focus the lawyers on a solution rather than just apportioning blame. The mediator provides a safe space for the parties to vent and tell their story. The lawyers sometimes use a mediator as a sounding board. Sometimes a lawyer may not have a clear idea of, what the possibilities are that they're going to win or lose, or if there's any other alternatives. And sometimes having a neutral party who is not invested in the case to bounce those ideas off can be very helpful. The mediator can help create options that were not thought of before. Sometimes you, as a mediator, pick up on something that one of the parties, didn't consider just by listening to them. And in that way, the mediator can help create some possibilities that didn't exist otherwise. A good reason to have the mediator involved is to assess possible outcomes. When a lawyer gets involved in the case, they really want to do the best for their client. They want to be their client's advocates. And sometimes we tend to get tunnel vision just a little bit. And we don't know exactly what's going to hit us, how we're going to get blindsided in litigation. So the mediator's role may be to assess the situation not only for the lawyer, but also for the client, so that the client can hear from an independent party how they're going to come across, what their potential of winning or losing. Sometimes the mediator is used to deliver a hard sell to a client. If they don't want to hear the bad news, the mediator can deliver it in a way that maybe their own client, or the lawyer, can't do it. So the mediator can be used in that way. Sometimes the lawyers may know that there is a result that needs to happen to get this case settled, but they can't tell their client. So the lawyer uses the mediator kind of as a scapegoat, which is just fine. The mediator can say, I'm proposing this. Your lawyer hasn't caved. The other lawyer, didn't come up with this, so that we get over kind of the issues of who's proposing the idea. The mediator can be the scapegoat, and maybe the case gets settled in that way. The mediator doesn't come between the lawyer and the client. It's your job to counsel your client, and hopefully you have a good relationship with your client, and the role of the mediator is to help you preserve that relationship. But the biggest part of it is to really help the parties keep talking. People get upset. Buttons get pushed. Lawyers get angry. Sometimes people just walk out because they don't want to talk anymore. And it's the mediator's job to keep people talking, because only through those continual conversations can the impasse be overcome. So as you're getting ready for a mediation, what do? Your first job is to define your goals. And unlike litigation, where it's win-loss, the goals of a mediation can be many. It may be how much money you're going to get out of it. It may be developing a process to complete a construction project, for example, or move through other kinds of disputes. It may be to preserve relationships where these people have to work together, husband and wife, for example, maybe in a homeowners association, all kinds of situations where the relationships are going to be ongoing and they matter. This process can help them continue those relationships. And it helps keep parties out of litigation. So you set your goals first and foremost and understand what they are going to be. The next thing is to develop your strategies, and you do that with your clients. And all of this is done ahead of time. Tell your clients what the process entails. Let your clients know what's going to be expected of them. Develop the strategy together. That enhances your credibility with your client and helps the process proceed in a way that's most productive. You talk to your client about what their interests are. What do they really want out of this? They want a certain amount of money, but why do they need it? Is it to pay medical bills? Is it something they can use to put a child through school? Do they need to pay off their mortgage? How are they going to use this money? What's their real objective? And try and think through what the other guy's objective is as well. That's how you prepare. That's how you prepare for your client. You decide what you're going to open with, you decide what your walkaway is going to be. And you talk about all those things ahead of time so that the mediation can be most productive.